I know that lately I've been harping on collections, but this time I want to talk about the levying of fines and the collection of fines and the use of fines to discourage behavior that's in violation of your documents. The law is pretty clear about the power to fine. Fining is probably a good idea but poorly executed, and here's why. In order to properly levy a fine, there are a whole bunch of procedural requirements you have to go through. You have to give 14 days notice to the owner. You have to give them a right to attend a meeting of the committee that will be fining them, or the board, whoever the prosecutor is, whether you have a fine committee or what have, or it's the board. The board at that hearing, where the owner has the right to probably bring counsel, I wouldn't see why they wouldn't have that right, and to cross-examine witnesses, which makes the whole process a lot more complicated than it was really probably intended to be. But at that hearing, the committee needs to take evidence and listen to the sides, whoever's going to be serve as the prosecution. Maybe it's the head of the rule enforcement committee or the restriction enforcement committee. And then you have to have kind of an instant court of appeals where there's a committee of people who have to agree with the decision to fine, and if they don't, the fine can't be levied. Now let's say a fine is levied, or I shouldn't say levied, let's say a fine is imposed. The fine can be $100 a day up to $1,000. What happens if the owner doesn't pay the fine? You have to go to the small claims court to collect the fine. Generally, it costs a lot of money and takes a lot of effort to go to small claims court. I guess the rules of civil procedure aren't clear. I suppose if a president wanted to go on behalf of the association and argue the case, that could happen. But small claims court is court, and there are county judges standing by to hear motions and other technical arguments. And of course, if you're going to have a lawyer go to that, it's going to cost money. And if the owner against whom the fine was brought brings a lawyer, there's prevailing party attorney fees. So you could be talking about maybe $5,000 in fees and court costs that are at stake. As a result, the fining process is not a kangaroo court. It's a series of highly technical steps that need to be taken in order to make sure that the association can validly justify the existence of the fine. And because the law was changed a few years ago to provide that you can't lien to collect a fine, it means that when you are successful and you spend all that money and you get a money judgment and a fine, you have to record a certified copy of the judgment in the public records, and then go try and find non-exempt property that you can execute on. And Florida is known as a great state for people who are debtors, and if someone's married, for example, you can't execute against a jointly held property, you can't execute against a homestead. So I really think that you should strongly consider whether fines are worth your time and effort. If and when you're challenged, I think you're going to find out that it's much more straightforward to go through the demand process, the mediation process, and then litigation if you have to. There is no easy way to enforce restrictions. Hopefully we would rely on peer pressure, at least in the old days, to stop that. But given the current economic condition, given the large number of rentals, and the economy generally, it's a very difficult situation, and it's something that you need to consider carefully before moving ahead. Good luck, and we'll see you next time.